Good morning to all of you in this beautiful, historic Malcolm Theater. It's a very beautiful morning, and no less than Malcolm has welcomed us. I congratulate the Justice George Malcolm Memorial Foundation, Incorporated, the Philippine Bar Association, and the IBP Journal for sponsoring this forum, whose principal on the Bill 9349, with the principal author missing us this morning. At the age of 88, I remain to be a student of law, and as one of the Constitutional Commissioners of the 1986 Constitutional Commission, who framed our present 97 Constitution of the Republic of the Philippines, I must forthwith state that the bill violates the Constitution and is unconstitutional. As a married Roman Catholic, whose beloved wife Gigi is here with us, to be sure that I will not change my mind, I also state that the bill violates divine law. I must first briefly explain why it violates divine law. God Himself decreed the institution of marriage. In the book of Genesis, chapter 2, verses 18 to 24, it is written, "That is why a man leaves his father and mother and clings to his wife, and the two of them become one body." Jesus Christ Himself strengthened and confirmed this divine mandate. In the Gospel according to Matthew, chapter 19, verses 3 to 18, Jesus partly said, "Have you not read that from the beginning the Creator made them male and female, and said, for this reason a man shall leave his father and mother, and be joined to his wife, and the two shall become one flesh? So they are no longer two, but one flesh. Therefore, what God had joined together, no human being must separate." This is also written in the Gospel according to Mark. The Christian religion includes marriage as one of the 7 sacraments. Thus, as divinely ordained and instituted, marriage is a sacred or inviolable social institution. It is until death do us part. Absolute divorce is not allowed. In our jurisdiction, this doctrine of marriage as an inviolable social institution was proclaimed for the first time in the Civil Code that was mentioned earlier. That Civil Code took effect on 30 August 1950. The Civil Code is an ordinary human law. Its Article 52 expressly provides in part, marriage is not a mere contract, but an inviolable social institution. This Civil Code doctrine of marriage as an inviolable social institution was elevated or raised as a fundamental law principle or as a constitutional policy or doctrine in our 87 Constitution, which took effect on 2 February of 1987. This Constitution actually enshrines the inviolable character of marriage as a social institution and as the foundation of the family. Thus, the family is also a sacred institution, which in turn is the foundation of the nation. The 1987 Constitution devotes one whole article for the family, and that is Article 15, Sections 1 and 2 of which provide as follows. Section 1, the state recognizes the Filipino family as the foundation of the nation. Accordingly, it shall strengthen its solidarity and actively promote its total development. Section 2, marriage as an inviolable social institution is the foundation of the nation and shall be protected by the state. And as this to sacredness or sanctity of the family, Section 12 of Article 2 of the Constitution on Declaration of Principles and State Policy expressly provides in part. Section 12, the state recognizes the sanctity of the family and shall protect and strengthen the family as a basic autonomous social institution. What is the scope of inviolable in reference to marriage as a social institution? In the New Oxford Dictionary, inviolable means never to be broken, infringed, or dishonored. In Webster's Third New International Dictionary, inviolable means incapable of being broken or destroyed, indestructible, secure from violation or infringement, sacrosanct, secure from assault or trespass, untouchable, unassailable. In Webster's New Word Codice Dictionary, inviolable means not to be violated, not to be profaned or injured, sacred, that cannot be violated or indestructible. Thus, marriage as an inviolable social institution by express mandate of the Constitution is sacred, sacrosanct, can never be broken, infringed, or dishonored. It is indestructible or is incapable of being destroyed. Our Family Code, Executive Order Number 209, promulgated by then President Cory C. Aquino, and which took effect on August 3, 1988, further clarifies and strengthens this mandate of inviolability. Article 1 of Chapter 1 of Title 1 on marriage thereof expressly provides in part. Article 1, marriage is a special contract, a permanent union between a man and a woman entered into in accordance with law for the establishment of a conjugal and family life. It is the foundation of the family and is an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation. Take note of the phrases: special contract, permanent union, and inviolable social institution. What was done there by the authors of the absolute divorce law to tempt or mislead the people into believing that the Constitution does not prohibit absolute divorce? They did it through magic and through misrepresentation. The magic is accomplished by surreptitiously introducing an amendment to the Constitution consisting of the deletion of the word inviolable in Section 2 of Article 15 in reference to marriage as an inviolable social institution. This amendment cannot be done by ordinary legislation, but only by either of the three modes of proposing amendments to the Constitution as provided in Sections 1 and 2 of Article 17 of the Constitution, namely by a constitutional convention, a constituent assembly, or people's initiative. The misrepresentation was done by making it appear that the Bill Section 2, entitled Declaration of Policy, or a declaration of our policy, that marriage is only a social institution, not an inviolable social institution. Misrepresentation. They have forgotten the word inviolable, or that inviolable is not in the Constitution. This Section 2 merely states that, open quote, marriage is a social institution, close quote. As one further reads the bill, he will sooner discover that it also weakens, demeans, degrades, debases, or even demonizes marriage as a sacred or inviolable social institution. It is making a bad joke on marriage. To illustrate, let me just mention a few. First, in its Section 11, the bill allows summary judicial proceedings for absolute divorce on some grounds, which was mentioned earlier. By its definition, under Section 4, summary judicial proceedings refers to an expeditious manner of resolving a petition for divorce without regard to technical rules, and the petitioner is given an option to be assisted by a lawyer or not. The family court may also allow the presentation of evidence ex parte, as enumerated by the law itself. The decision shall be immediately final and executory. Needless to stress, it would be easy for a couple to avail of the Section 11. Second, as provided for in Section 5, it converts with modifications as grounds for a judicial decree of absolute divorce the grounds for legal separation under Article 55 of the Family Code, and the grounds for annulment of marriage under Article 45 of the Family Code. The modifications consist of in relaxing some grounds and adding new grounds, such as when one of the spouses undergoes a sex reassignment surgery or transition from one gender to another sex. All of the modifications are intended to make it easy to secure a judicial decree of divorce. Third, the recognition under Section 6 of foreign divorces by either alien or Filipino spouses as having the effect of divorces under the Philippine law. It is not required that these divorces be for any of the grounds provided for in the bill. It can be for any other ground. Therefore, the parties can obtain absolute divorce in Las Vegas, USA, for any reason whatsoever. Fourth, in Section 7, the bill now yields to the finality of valid, canonical, or church dissolution or nullity of marriage adjudged by the proper matrimonial court of the Roman Catholic Church or any other recognized sect or denomination. It is not required that these dissolutions or nullifications of marriages be for any of the grounds prescribed by law or under the bill. Thus, the Catholic Church and any other religious sect or organization may grant dissolution or nullification of marriages on other grounds than those prescribed under our present law or under the bill. I am afraid that some groups may for profit form a religious sect for the business of celebrating marriages and dissolving marriages. Kibuloy may now register his group for this purpose. Fifth, it dignifies what today may be nature-defying and morally unacceptable sex exchange by making as a new ground for absolute divorce in Section 5 of the bill such exchange through sex reassignment surgery or transitioning into another sex through the use of hormones or surgical procedures. Worse, if either is invoked as ground, summary judicial proceedings is allowed. Sixth, under Section 12 of the bill, expert testimony is dispensed with unless the proper family court decides such testimony is indispensable. All told, therefore, absolute divorce bill would do more harm, irreparable harm, than good to our sacred and inviolable institution of marriage, to our families, and to our country. Some sectors claim that our Constitution does not ban or prohibit absolute divorce because in the book of Father Bernas, the 1987 Constitution commentary, it was stated that during the debate in the Constitutional Commission, Father Bernas asked whether it prohibits divorce. And Chito Gascon answered that it does not. So that is the basis now for the claim that the Constitution allow. For the enlightenment of all, the exchanges between Father Bernas and Commissioner Gascon took place during the period of sponsorship of the proposed article on the family. It was not during the period of amendments. The exact wording of the draft provision as modified was marriage is the foundation of the family and should be protected by the state. The state shall respect the family as an autonomous social institution. This is the basis for the claim of Commissioner Gascon that divorce is not prohibited. This can be found on Volume 5 of the Constitutional Commission record, page 55. But during the period of amendments, Commissioner Regalado Maambong introduced the amendment, which the committee accepted and which the plenary approved. This is the Maambong Amendment. Marriage as an inviolable social institution is the foundation of the family and shall be protected by the state. That is Volume 5, Record of the Constitutional Commission, page 56. To repeat, the Bernas issue related to a proposed provision that did not yet contain the word inviolable. In light of all I have stated, it is obvious that absolute divorce is absolutely prohibited under the 1987 Constitution. In short, an absolute divorce law would be unconstitutional, no matter how beautifully worded or embellished or made attractive. Thank you for your patience on this divorce law, and may God bless us all. May God bless Filipino marriages, Filipino families, and our Filipino nation. Thank you very much.